Thank you, Florian, for that introduction. I'm Paul Karlsgodt. I'm with a partner with Hostetler in Denver, Colorado, and I am the team leader of our newly formed digital assets and data management group. I lead the team litigation. So pleased to be a presenter here today. And with me today, we've got three very knowledgeable lawyers. First, Robert Boone, who's a partner at Bryan, Leighton, Paisner in Los Angeles. He is the leader of Bryan class actions practice group. And he also has significant experience representing financial institutions, retailers, and food manufacturers in class actions around the United States. Also with us is Jeremy Lieberman, who is Pomerantz's managing partner. He's received numerous honors for his work on the plaintiff side as a class action litigator, including Benchmark Litigation's 2019 Plaintiff Attorney of the Year and being named a Titan of the Plaintiff's Bar by Law 360 in 2018. The Pomerantz team that Jeremy leads was named a 2018 Securities Practice Group of the Year. And Jeremy has served as lead counsel for plaintiffs in some of the largest ever global securities class actions, including the Petrobras securities litigation, which was a closely watched securities class action arising from a multi-billion-dollar kickback and bribery scheme involving Brazil's largest oil company, and I'll butcher the name, but I'll say it's Petrobras. And also with us is Chris Warren-Smith, who is a partner with Morgan Lewis in London. He has a truly international practice and long experience in supporting clients with class and group actions, managing crises, and handling regulators in the UK and around the world. Chris brings a broad international perspective to today's panel. And today we're going to be giving you the perspective of the sort of the corporate perspective, advising corporate clients in navigating the global landscape of class actions. So over the past couple of days, you've heard a lot about how class actions are developing both in the United States and around the world. And we'll be talking today about, given that landscape, how those of us on the defense side are giving advice to our clients on trying to mitigate the risks associated with class actions. And Jeremy will be giving us more of a kind of a global perspective on what the plaintiff's bar is looking for, which will help us guide the conversation on how we would counsel our clients to hopefully avoid some of the pitfalls of global class action litigation. So I'm going to start by posing the question to Jeremy. Can you give us an overview of the factors that are driving class action litigation, both in the U.S. and also then what you're seeing driving collective or group litigation around the world? I think Jeremy may be on mute.
Can you hear me now?
There you go.
And thanks a lot, Paul. And it's a pleasure to be on the panel. And thanks everyone for participating. That's a great question. Is what class action litigation? I think it's really to answer it somewhat facially or facilely also is that it's really what you read about in the newspaper, the issues you're reading about in the newspaper, the problems that you're reading about in the newspaper. So, I think, and consistent, Paul, with your practice, clearly data breach litigation is, and privacy litigation is definitely something that's driving a lot of securities class actions. It's driving a lot of class action litigation, generally in the marketplace. Obviously, we're all going through the COVID crisis. That on its own, colleges and tuitions and which are still haven't moved and fees and such that have been that are being paid even though the virus is still limiting education or limiting the type of education that people are used to receiving and expected to receive. And so those are clearly things that drive in the marketplace. We see a lot in the securities space. There's a lot of litigation that's dealing with really just pharmaceutical companies generally, where you'll have drug companies that really have a pressure that they're really like a one drug wonder company, and there's significant pressure up on this company and significant incentive to really prop up the results of the clinical trials and to do what they can to make it look better, to then issue offerings, maybe whether it's done purposely or whether it's done just maybe overly excited about the prospects of their own pharmaceutical. There's clearly an incentive to prop up the prospects and maybe sell some securities as well. So those really the events that drive the conversations at the kitchen table to a certain extent are the events that drive class action litigation. Broadly, I think the key things that are really hitting global class actions are global mass litigation. I mean, not every jurisdiction has a class action, as it has been discussed numerous times on various panels. But the things that I think people are having a very global impact are securities. Clearly, there's actually a ruling in 2010 in the Morrison case where the Supreme Court said if you purchase your shares outside of a non-U.S. exchange, you're not covered by the U.S. federal securities laws. And so basically said, we don't want to hear your claim if the securities are not traded in the United States. And people thought, well, maybe this would somehow limit litigation. It actually just created a huge marketplace outside the United States, because what happened was people said, whereas cases that wouldn't even be covered previously in the United States, we had real, large asset managers saying, wow, well, I can get a recovery in the U.S., and I can't get something outside the U.S. That doesn't make sense. And it just really created a huge demand. And that decision was meant to really, constrict litigation. But that's, the way these things go, it actually spawned huge amounts of litigation that I don't think anyone had anticipated. You see also in the Forex litigations, the LIBOR benchmark litigations, basically, where there's a lot of rate riggings and things like that. That, again, has spawned a very huge response in the United States. There's been billion-dollar settlements, and a lot of institutional investors or market participants are saying in the UK or in Europe are saying, hey, what about us? Why can't we get anything here? And I think that's driving, to a certain degree, a lot of litigation. That's what we see in the space, really kind of driving a lot of the global litigation throughout the world. Paul, I think that you're on mute. Yeah.
We'll have that problem several times today, I'm sure. So just a follow-up question for you, Jeremy. It seems to me, just from my observation, that in the U.S. there are at least two different types of class action litigation. There is that class action litigation that is driven by either the marketplace or the plaintiff, the individuals that have an incentive to bring the case. There's also a certain aspect of litigation in the United States that's driven by sort of the entrepreneurial spirit of plaintiffs' lawyers themselves. And what do you see globally? My impression is that you see less of the sort of the entrepreneurial litigation outside the U.S. And more of the litigation that was driven by an actual scandal or by an incentive by the individual litigants to bring cases. Is that correct, or are you seeing that same dynamic?
That has some truth to it, only because just there's less, class action or litigation generally opportunities outside the United States. I mean, in much of Europe, you don't have the ability to work on a contingency fee. You have to deal with third-party funders and things like that. I think that's becoming less true, actually, and I think the only difference is really the economic incentive there. I mean, it's clear in the United States that don't quote me, but I guess I'm on air. So it's obviously to a fair degree lawyer driven. A lot of litigation. You do get calls. I mean, I can tell you a lot. We do get calls from investors, things like that. But typically, as experts in cases, and whether securities, which we focus on mostly, or antitrust, whatever it is, we know which case is going to succeed. So the cases are going to be brought are going to be the ones that the experts believe, hey, this has a real upside. The one that people call you on, it's very rare. I'd say about 5% of the cases come in where somebody actually brings you an idea. You say, hey, you know what? That's a really good idea. Not because not because that there isn't a push for litigation by the consumers of the marketplace, but there's just lack of knowledge. They don't know what cases will succeed and what will not. I think you're seeing now, particularly, I mean, we're very, in the security space and in the kind of antitrust space, and I'm speaking more now about the benchmark cases. You're seeing it's not necessarily lawyer-driven. You're seeing really driven by, third-party funders. Some can be driven by law firms, exporting their goods. In the United States, we're helping to organize a few cases in Brazil and in Denmark. So you're starting to see kind of it's third-party funder, driven to a certain degree in Europe. But you're seeing a lot of that. I think, and I think you're going to see that not because people say the term lawyer-driven is a bad term. Think about it. It's really just the lawyers and people funding litigation are the ones that know or have a sense as to this might succeed. So it's always going to be, as long as the plaintiff's lawyers are have an incentive in the cases, or some participant has an incentive, or a third-party funder or lawyer, it's always going to be driven by the lawyers to a certain degree because they know what will work and what won't work. So I think as more opportunities increase globally, I think there's a lot of sense, and people have said, well, we don't want to bring the bad U.S. system to Europe. And as much as people say that and beat their chests and shake their fingers and shake their heads so ominously about this, it's inevitable. The U.S. system allows for the most expedited, efficient system where people can get involved and bring a claim and try to resolve them thus far. And a lot of people in Europe see that, and as people have international transactions and see, I can get money in the U.S., I can't get money here. Well, why not? The demand's increasing also in Europe. So I think as the opportunities for plaintiff side litigation increase in Europe, i.e. contingency fee and no loser pay and those types of opportunities increase, you're going to see an increase in what you've called perhaps derogatively, lawyer-driven litigation. Although you didn't use the term, so I'll give you credit, Paul. You didn't throw out that moniker.
I said entrepreneurial, so that's my.
You're correct. Yes, you're right.
So I'll turn to Bob now. Given that landscape, as someone who regularly represents and advises corporate clients in the U.S., what types of advice are you giving your clients on how they can avoid the prospect of class action litigation, both in the U.S. and outside?
Thanks, Paul. And it's a pleasure to be on the panel with everyone. Good morning, good afternoon, everyone. Thanks for attending. It's very, very difficult to avoid class actions for corporations, companies these days. It really is a minefield, the complexity of which is limited only by the creativity of I think the plaintiff's bar and regulators, which also spawn class actions around the world. And in particular, businesses that are consumer-facing or in highly regulated industries, publicly traded companies, businesses that have a menu of fees that generate significant sources of revenue for them, businesses that automate the delivery of their products or services, and businesses, for example, banks that have ongoing interactions with their customers. Those kinds of businesses are particularly vulnerable to class actions. And so really the key, I think, is you want to try to control and mitigate. And one of the ways that I always talk to clients about a way to mitigate is and control is, to the extent that you can't always do it because tort claims and statutory claims are often a part of class action claims. But to the extent that you can, you want to leverage whatever contractual relationship the company has with its customers. And those can be in the form of various contractual clauses, class action waiver clauses if you're in a jurisdiction where those can be enforced, mandatory arbitration provisions, warranties that may limit liability or provide for exclusive or certain remedies, disclaimers of liability, even satisfaction guarantees. For example, in the grocery store business, a lot of grocery store chains have satisfaction guarantee, where if you're not 100% satisfied with what you bought, you can bring it back and you can get a full refund, no questions asked, or replacement product. And oftentimes in class actions, on the defense side, you end up arguing that, look, there was a product recall, or we've got this 100% satisfaction guarantee, and there's no need for class treatment in this case. Anybody who's adversely affected can go back to the store and swap out the product or get a full refund. In addition to, and there are also forum selection clauses if you want to try to control, and governing law clauses if you want to try to control the applicable law or the venue where the forum where you might be litigating the case. You always can't enforce these kinds of provisions, but at least you ought to be thinking about them. I always counsel clients to have a rigorous legal compliance risk mitigation program. That is what that consists of is going to depend upon the nature of the business that the company is in. It's always a good idea to involve legal counsel, whether that's in-house counsel, who are subject matter experts in the particular type of business or business unit and what they do, or outside counsel. The purpose of that, and then you want to be interfacing with your business unit leaders, particularly if you're launching a new product or service, if you're making changes in your products or service lineup, or if you're expanding into a new geographic area. You want to identify, as I mentioned before, what the minefield is, and so the potential risk, and put in place protocols for compliance with applicable regulations, and then establish metrics and reporting so that you're periodically looking at your compliance. That can reveal repeat events that might be actionable. It can identify unintended consequences, and it can identify patterns of non-compliance with applicable regulations. You also want to have feedback loops, and that involves having coordination with, for example, a customer service department. And if a company has customer complaints, yes, they want to be addressed, but people in the customer service department should be connected to the legal department so that the legal department can see if, okay, do we have a problem here? Is this systemic? And then it can be addressed. The other thing to always do is to analyze individual lawsuits that may be asserted against the company for a potential class risk, and then obviously be proactive in addressing potential problems. I always counsel clients, and they know to do this for the most part, to avoid media risk. Media risk can, as Yuri mentioned at the beginning, class actions are really about what's happening in the media. So negative media risk can spawn class claims. And you want to also pay attention to class actions that may be asserted against your competitors. And then finally, I think it's really important for companies not to take shortcuts in their business. Most of the time that gets caught. We saw that with the Volkswagen diesel scandal. So those are some things that I would counsel clients to have as part of their risk mitigation program.
Well, I'm going to turn then to Chris and ask you, Chris, from the perspective of someone in the UK, and my assumption is you deal with a lot of European clients. Are you giving the same types of advice? Are there any differences?
Can you hear me now?
Yes.
Great. Much the same. Rob's really covered off the sort of the basic framework of how many businesses are looking at this. I think the only things I'd add is, and however clients are doing this through their risk assessment program or within business lines or otherwise, probably the most effective things we're seeing are when people are standing back and looking at their risks holistically, which I think Bob touched on, and that really understanding the dynamics of change. So obviously, in the EU, there is about to be a significant change, which will in effect have a level of retrospective operation. So what does that mean? So you need to look at your consumer-facing businesses, the types of territories you're doing it in, the types of business you're doing, to see where that risk first arises and then may manifest itself. And so really the risk assessment at the macro level is a lot of what can drive very effective management in dealing with all the sorts of things that Rob mentioned, the contractual terms and the like. And so really that's the broad point I would add. I think the other thing we're seeing clients doing, perhaps more outside the States, is that the US has a more developed sort of regulatory enforcement and private sector litigation in the class action space than other parts of the world, is really understanding where those risks interface with regulatory risks in different territories. So, for example, where you have any sort of consumer-facing issue in the UK involving financial institutions, historically there's been a whole different range of solutions that have had different levels of regulatory involvement outside the courts, and sometimes in conjunction with the courts. So I think part of the additional risk assessment, which happens in the States, but it's more in some ways because of the diverse nature and the differences, there's probably more scope for engaging with those risks and making practical decisions outside the States. And the other thing that I think we're seeing clients do is work out how to manage those risks in practical terms. And very often it'll be part of a crisis management preparation process that they have. I mean, different people do this ways, in different ways we work with clients. We'll do tabletop exercises, we'll do all sorts of other exercises where people can understand these risks and how they manifest themselves, but both of themselves, so the risk of collective litigation or class actions, but also how they're going to interface with the other dynamics, such as regulators and other key stakeholders when these risks arise. So some of the really effective things we've seen are where people are doing crisis planning, preparation and training in a way that does help them really to be able to deal with these issues in a real way, as and when the issues come to manifest themselves. So that's probably the other practical thing I'd add to what Rob said.
Turn then to the parts of the world, and I'll ask Jeremy first. Where is the plaintiffs' bar looking geographically outside of the U.S.? Clearly, U.S. is a hotbed of collective and class action litigation. But where else are plaintiffs looking to bring cases given the kind of the changing landscape? Oh, you're on mute again.
Yeah, so to a certain degree, wherever the activity that one is seeking to litigate is being brought. There have been cases in Brazil, as I mentioned, in Japan, in Italy, in UK, in the Netherlands particularly. The Netherlands, there's been some for securities cases and other cases. There's been a ability sometimes to get some worldwide jurisdiction. It's been certified in certain instances. So that's been somewhat of there have been certain draws to bring cases there. But really throughout, there's certain jurisdictions. Canada and Australia already have a somewhat developed system. Israel already has a developed class action system. So there, for sure, I mean, there's not even necessarily a point for us to get involved because it's already developed in the sense they don't need our quote unquote help. Where you're seeing things where there's movements is definitely in England. You're seeing more, antitrust. You're seeing more securities. Again, not necessarily class actions, but mass actions and group actions. Germany, after the Volkswagen issue, we brought in the Danske Bank case in Denmark. So really, I'd say it's really where the activity is, and then trying to come up with a solution as to how can we proceed in this jurisdiction on either a class basis, which is there's certain mechanisms available in Germany. So you'll try to bring something there if you can, or if it's in the Netherlands, there's also certain mechanisms that allow for some form of class-wide relief. But wherever you can get jurisdiction. So, but it's as far along as South America, Europe, Asia, wherever the case and opportunity might be. Again, a lot of the activities is driven by, I think, people saying in those countries or wherever saying, well, if there is a solution in the United States primarily, why isn't there a solution here? And if the reasons are because of problem A, loser pay system, B, no class action system, or C, no contingency fee, then there's all these kind of attempts to work around those barriers. But there are attempts everywhere. I think one thing. I'm not sure if this was covered in other sessions, but it tells you. I mean, it should be good news, I guess, for all of us. But not necessarily good news for all your clients. Is that really given what shows me where class actions are going and how I think it's going to really just increase globally on a very large basis. And even though there have been attempts in the United States to stymie class actions by arbitration clauses and things like that, which have become extremely unpopular, you just have to watch the Bombshell, and movies like that. That's tell you about what arbitration clauses mean. But so as much as there have been efforts to limit class actions in the United States, the involvement of litigation funders and really look at who the litigation funders are. You used to see some very I call it like shady or very a marginal players be involved in litigation funding 10 years ago. Now you're seeing it's major hedge funds, major banks, really serious institutional names get behind litigation funding because they see the opportunity. And when you have this kind of money, I mean, it could be a bad thing for the companies. When I see this, I see real money, smart money, betting on the growth of class actions and group actions and things like that. It tells me, it's here to stay, it's here to expand. People might say, well, that's a horrible thing. I mean, you just have to think of rationally. The world has become much more globalized. The companies are becoming so much larger. They have so many, their stock, you have stock valuations of $1 trillion now. You have, earnings in billions and hundreds of billions of dollars. And you need, if, not everybody on that side acts, or always acts with complete, innocence. And sometimes they owe the other side of the party money for some reason or the other. And there has to be a way to collect that money. And the only way you can do so in an efficient way is a class mechanism. That's just, common elemental sense. And people are seeing that. And whatever they want to say about lawyer-driven litigation, and we don't want this kind of, aggressive style being exported, that's just a basic fact. Not every corporation always acts, with complete, perfection. They sometimes owe their stockholders, counterparties, or consumers money, and then you have to figure out a way how to get that money and how to litigate that issue and to verify how much money they owe you. That's only can be done by class action. And I think these huge, very large hedge funds see this, very large, even institutional investors see it and are investing in it because they see this just as large as Amazon gets, you're going to have class actions, that represent that huge growth, and people see that and are investing in it. So, that's I think you're going to see in the next decade or 15 years, globally and in the United States also to a certain degree, you're going to see really, a huge spawning of this as companies are getting larger and larger and more interconnected and more globalized, and mergers are getting larger. So too, the class actions themselves are going to get larger. I mean, imagine, God forbid, imagine a Amazon or a Facebook, tanks and implodes the way Enron did or WorldCom. So Enron and WorldCom were $70 billion settlements and $6 billion settlements. Again, God forbid, I'm not wishing for their implosion. I think these are great companies. But God forbid there's a scandal of that magnitude on one of these $1 trillion valuations. What are you talking about? What are you talking about as far as potential class action settlement? You're going to start to see $10 billion settlements, 15, 20, 30, 40, 50, 100, and more. It's just because the size of the companies. And so just extrapolate that way. And so, and the smart, keen, savvy hedge funds, not just, I hate to say it, I went to a litigation funding meeting about 10 years ago. You saw some people they didn't have, not nice to say that, like they had gold teeth in the front of their mouth, really shady looking kind of characters. Is much different now. These are smart, sophisticated people. I mean, you see, Fortis Bank, you see others, Fortress hedge fund have these class action divisions. They're investing because they say these things, a problem. Amazon has a problem. It needs a solution, and we need to come up with a mechanism. The only way to do it is a class action. We're going to invest in it. So you'll see a huge spawning everywhere.
So, given that that kind of change in the landscape, and I'll turn to Chris. As a practical matter, what are you telling your clients about the increased access that the plaintiffs bar is having to these types of mass mechanisms, and what are some of the barriers to its further development? In other words, what truly is the risk for a company that maybe isn't engaged in a global scandal, but has kind of the normal business risks? Where are you kind of focusing your mitigation efforts in light of that?
Yeah, and it's very much a developing risk in different ways at different times. And to some extent, we can track the risk just by looking at some of the developments that we're seeing. So, for example, we're definitely seeing a cultural shift. If you pick the EU, I remember about collective actions, 50 people, only a couple of private practice lawyers, a whole range of other people. Now, we were not allowed to use the phrase class actions. There was an absolute terror of plaintiff lawyers in Learjets. And the whole discussion was premised on that. And I remember walking out of that meeting, so 13 years ago, thinking, well, I will never see any pan-European solution in my professional lifetime, let alone possibly my mortal lifetime. And here we are with something coming into force probably next week. So what you've got is a massive cultural change. And I think you're starting to see that more and more around the world. You're getting indications from countries in Asia that there's an interest in this sort of thing that wasn't there before. So I think there's definitely a cultural shift that's making a difference. Another thing we're starting to see, and it's starting to come to a little bit in some of the COVID-19, in the labour force and elsewhere, is increasingly governments are more open to private sector solutions for public sector issues. Again, in Europe, we've had the competition authorities really leading the way on this for a long time. But really, as time goes by, and this is where Jeremy talked a bit about the litigation funding sector, this is another thing that's moving into the space, and there's likely to be a greater tolerance for authorities. Rather than be responsible for enforcement, they can have a private sector solution in whole or in part that enables those sort of behaviours to be enforced. So there's certainly, we're seeing around the world more openness towards allowing the private sector to fill in that gap. And so that's something we also advise clients to be careful of. And the other really important thing is people underestimate the third-party funding. And don't forget, in some ways it came late to the States. It started off in Australia in the sort of mid-90s, about 10 years later over here in the UK. It wasn't really necessary in the same way in the States because of the plaintiff law firm model. And there's a lot of trial and error that's gone into that space leading up to where we are now. And what we're seeing is very sophisticated, intelligent funders deploying capital very intelligently and strategically. And so that is a fact. And we're involved in some of the early, going back 10 years, some of the early funded cases, and it was a lot less slick than it is now. You wouldn't be surprised to see that. But what we've really got now is people who know what they're doing. They're using their capital well. They provide a lot of support to the law firms. And also we're starting to see outside the States more of a plaintiff bar. Some of the people I'm sure Jeremy will be working with now are more experienced than they were 5 or 10 years ago. So really the message for clients is do be on top of this space, do understand and try to mitigate the risks. And that's, again, what we factor into the thinking about how they deal with a lot of things that Rob mentioned earlier. Looking at it, what you do, where you do it, and what it is. So that's probably the main points I'd make, Paul.
So let's turn then to the scenario where you've got a global client, a multinational company that does business in different jurisdictions, and they have been sued in the United States, and let's say that they now are facing some form of litigation in the UK and South America and continental Europe. I'll ask Bob first. Talk a little bit about how you go about coordinating that kind of effort from the defense perspective.
Sure. Ultimately, the strategy, and you need to have, my view is you need to have coordination between your in-house counsel and your lead outside counsel in each of those jurisdictions where you're at risk. A lot of sophisticated clients these days will have 1 or 2 law firms that will lead the defense of a certain type of litigation. They typically are chosen because they're subject matter experts in that particular area. They may have regulatory expertise as well as the litigation expertise, because oftentimes when you see large scale litigation, particularly across multiple jurisdictions, you're going to have regulatory scrutiny of some sort. So you also have to deal with that. But I mean, ultimately the strategy is what's the end game for the client? And some of the high level decision points that I think you have to make when you're facing multiple jurisdiction litigation is identify the most important decision points in the lives of the cases and what key issues need to be addressed and when, and which court or judge do you want to address those issues, and in which cases do you want those issues to be raised. For example, if the client has decided, okay, well, we need to actively defend these cases. In the United States, you have the possibility of MDL litigation where you can coordinate perhaps some of that across jurisdictions, and the client will have to decide whether they want that. They don't always have a choice. The courts can institute that. The plaintiff's bar can institute in MDL proceedings or ask for MDL approval. So a company doesn't always have complete control over that, but it's something that should definitely be addressed. So it really boils down to picking your battles, if you want to fight them, where you want to fight them, and when you want to fight them, because decisions in one case in one jurisdiction can impact decisions or the outcome in other cases in other jurisdictions. And ultimately, I think you want to avoid the client taking inconsistent positions across multiple jurisdictions. That's, if there's coordination on the plaintiff side, that's going to come back to haunt the client typically. So you definitely want to avoid that unless you can justify it because of applicable law. But those are my thoughts on how you coordinate.
We got a comment audience that I think is worth commenting on, and I will ask Chris this question because it has to do with the strategy that may be employed in some parts of the world where you file proactive action. This comes from Ionica. In the EU that they would file what they call a torpedo action to torpedo the potential for the litigation. Can you talk a little bit about that as a potential strategy, Chris, and other strategies that you might employ when you're engaged in a sort of a global defense where you may have also litigation pending in the U.S.?
Yeah, and it's certainly the colloquialism used to be the Italian torpedo. And post-Brexit, there's more scope probably for that happening more again, like the old days, so to speak. And that's something that we've been involved in those cases where a client, we had one example based in Italy, we filed the case there when there was very limited connection. Proceedings ultimately went ahead in both Italy and the UK. So it's something that has been common and is likely to become perhaps more common again. And that's really goes to picking up on some of Rob's point, which is risk assessing all the outcomes, all the opportunities. Typically, the client will have, when we're talking about these sorts of issues, it's a serious issue. It could be affecting a share price. It could be affecting the boards all over it. And so really, you're looking at resolutions in a way that's acceptable. And so a lot of those sorts of issues will drive decisions like the type of Italian torpedo. And interesting, the question was asking whether it's something that is common in the US. But my experience is it's possibly less common. Typically, the US authorities will grab jurisdiction based on a US dollar passing between two hands anywhere in the world, and that can play into the court system. Although we've talked about Morrison already, so I think it's probably more common outside the States. In my experience, there's probably more scope for using those sorts of strategies outside the US.
Yeah, I'm going to tell you that I'm going to start using it for one. So you're going to start seeing it more in the US. Because I think it's a good idea. In the few minutes we have left, I'd like to ask each of the panelists to kind of give us your bold future predictions for the development of class actions that affect companies that do business around the world. I'll start with Jeremy. You're the one on the front lines thinking up the litigation. So what are you thinking companies are going to be facing in the next 5 to 10 years?
So I think that hopefully I'm hope that reason will prevail. It'll happen at some point. The question is it decades or is it longer? Where if you have one type of bad action, let's say like rate rigging or securities fraud case, there wouldn't be multiple jurisdictions and with diverse rulings and diverse standards. It just makes absolutely no sense. If someone rigs the same LIBOR rate and they can get one type of recovery in the U.S. and different type of recovery in the U.K., they're just nonsensical. So I hope that you'll see in the next 10, 20 years where maybe there'll be signatories like, to a certain degree, like a Hague Convention, as it were, where for these certain types of cases, securities, consumer, antitrust, there will be one standard of laws and one jurisdiction, agreement to have these in one jurisdiction where all participants that are hurt by a defendant's common misconduct could be heard in one jurisdiction. I think as globalization intensifies and increases, we've maybe had a step back with COVID and certainly with the current administration from globalization, but it's kind of it's hard to stop technology, and so you'll see a demand at some point for a unified standard, unified forum where all claims can be heard. That's really what we for class actions. That's ultimately what we're achieving, right? You had disparate cases with thousands of plaintiffs. Finally, in the U.S., they got smart, I guess 50 years ago or so, or 60 years ago, and put it all in Rule 23 in one form, and then you got involved in MDL panels where you put it all in one courthouse. Well, gee, that makes a whole lot of sense. Everybody knows that makes sense. So same concept, and it'll just have to be, we have to get it all in one form globally. And again, where that'll be, I don't know. I assume it'll be a process of getting countries to sign on to that type of process and system. And it might be, it's not 5 years from now, it's probably not even 10 years from now, but that is where this should go. And the demand will be that it goes there. It makes no sense if I buy a security in London, or I buy it in the US. One place I can get, because the law is better, I can get $15. Another, and it's the same law, it's the same misstatement by the company. Another place the law is worse, I can get $3. That just makes absolutely no sense in a globalized world. So I think that demand will happen. I hope we're all in practice to see the day.
Bob, what are your thoughts? What are you going to be counseling your clients on what they should be expecting over the next 10 years or so?
Well, I think what Jeremy just talked about is really interesting, and I think that we may be headed in that direction. I think on a global basis, investor lawsuits and data privacy are two areas where we can see truly global class actions being asserted. It's going to be interesting to see if in UK and Europe, whether consumer class actions catch on as they have in the United States, and whether the court system's reactions to consumer class actions is going to be the same as what I believe it was in the United States, which has resulted in a more rigorous analysis of, for example, class certification issues, making it more, as we discussed in some of the other panels earlier, trial-like, more difficult to actually get class certification. That may happen in the shorter term before what Jeremy is talking about may happen. But I think eventually what Jeremy is talking about will happen with respect to investor and data privacy type claims.
And lastly, to you, Chris, a few predictions.
All of those things. I think there's no doubt that this is going to continue to be a growth area in general for all the reasons, all the dynamics we've discussed here. I think what we are going to see, though, is looking at the geopolitics of China, US, etc. I do think we're going to start to see a difference between East and West, so a different framework. The sorts of frameworks we're talking about may not be possible across that divide. So I think, the Middle East. So I do think that, yes, we're going to see significant increase, but increasingly it's going to be perhaps outside those dividing lines. So I think that's something clients should be watching for, the increase, where the risks are, how they're manifesting themselves, but also look at their business in light of those risks with those sorts of geopolitical things in mind.
Well, I believe we're out of time for the panel. I really, really appreciate the participation of each of our panelists. Really great insights. As always, I learned a lot. So thank you very much.
Thank you, guys.